You had a blood alcohol of 0.224, almost 3 times the legal limit. 4 prior felony OWIs, 13 prior jail terms, 2 prior prison sentences, violated parole previously. The offense occurred approximately 4 months after the beginning of parole. Drove reckless according to the information provided in the pre-sentence report, with 2 minor occupants in the vehicle, and the child calling expressing fear.
He was operating while intoxicated with 2 kids in the car, and I certainly don't mean to minimize that, but his girlfriend was in the car with him too, and she's here along with her child. Those 2 children had gotten in a fight, autistic children, at the home prior, and he needed to go home because they were actually physically fighting. They called the boy's mother. The boy's mother was unable to come and get him. And the car was a stick shift, so Mr. Thomas was the only one really who could take care of that situation. He drove almost 20 minutes when the boys started fighting in the back of the car again, and he turned around and yelled at them, and that caused a call to his mother and saying that Mr. Thomas was dangerously driving along the road. He was met by a police officer along the way. There was no accident, there was no swerving, there was nobody indicating that he was a dangerous driver. And like I said, Ms. Hicks is here today. When originally sentenced, the parties, the prosecutor and the defense, had agreed to TRC. And Your Honor seemed to be inclined to sentence him to that. You said at the prior sentencing, I would send him to TRC in a heartbeat, but I have to follow the law here. That's why the sentence is MDOC. And the law didn't actually say that he had to go to MDOC. So now his new guidelines are 12 to 36 months. And because it's a resentencing, I would ask you to consider the mitigating factors that weren't submitted previously, as well as his behavior since he's been in MDOC, which could be considered by this court. Judge, when speaking of the offender, I've had a lot of resentencings, and no one is really more deserving of a mitigation to his sentence than Mr. Thomas. He's had a very difficult life. Born to a heroin-addicted mother, never knew his father, devastated when his mother basically abandoned them to foster care. The first foster home he was in, he was sexually assaulted. Another where he ended up for quite some time, the mother was a schizophrenic addict and she OD'd. So very troubled history, obviously, which led to the drugs or the alcohol in order to cope with his unprocessed trauma. Just prior to this incident, his wife of 7 years was lost to another tragedy. She was given a Percocet by a supposed friend, and it was actually pressed fentanyl, and she died. So this doesn't excuse his behavior, Your Honor. Obviously, it's a very serious offense and something that needs to be considered, but I ask that you consider Corey and his life as well. Currently, he's completed ASAB, which is, the Advanced Substance Abuse Training within MDOC, receiving excellent and good remarks. He's had 3 jobs since he's been there. His most recent job, he's actually outside the prison gates working in their distribution center for the prison. The 2 that he's received remarks on were both excellent, including one where he got a 39 out of 39 for his job status there. And I would ask Your Honor to consider a sentence at the bottom of the guidelines based on these factors.
Does your client wish to address the court?
I believe he does.
Sir, what would you like to say?
Good morning, Your Honor.
Good morning.
First of all, I'd just like to take a second to thank everybody for their time and consideration at this morning. I guess one of the most important things that I'd like the court to know is that I do have general remorse for the fear and the danger that I put other people at, and I take full responsibility for that. Taking full responsibility for that to me means doing something about it, and that's what I've done with my time. Since I left here, like Ms. Bickerstaff said, I've had 3 jobs, 2 of which I work outside the prison gates. I've attended AA on a consistent basis each week. I poured my heart and soul into completion of the Advanced Substance Abuse Treatment Program. And I provide the final report for Your Honor to review for the courts to have, as well as the #1 thing that I've done is not only worked on but customized a relapse prevention plan. which I didn't have prior to this. It consists of 6 things which can make the difficulties in life and the choices that come at me somewhat simple. And those 6 things I practiced and used every day. That's taking a moment to stop and think, being deliberate about people, places, and things, making sure that my reactions and my thoughts are objective, asking for help whenever I can, using substitutes, such as a quiet time every day, going outside, working out, and really just staying focused, coaching myself. When hard times come, speaking to myself about what I need to be doing. Today, I stand in front of you again with my head held high, saying that I've been sober for over a year, clean and sober. And I'm proud of that. I know now today that addiction is part of who I am. But just like an individual that has diabetes, I can manage my addiction if I do these things. But you know, my addiction is not my sobriety is not a destination, it's a journey. For the rest of my life, I have to practice these things. And if I do that, then I can continue to be successful. One of the number one things I hear about every day in prison is what people are going to do when they go home and what they're going to have and what their future is going to look like. When I think about going home, you know, as she mentioned to Your Honor, my wife passed away about 5 months before I relapsed and caught this DUI, so going home will never be the same for me. But I have the most precious thing she ever gave me, and that's my daughter, and my daughter has my grandkids, and they're still behind me. When I think about my future, one of the things my dad used to say to me all the time comes to mind. He would say, if you want to do something well, then find others that are good at that and hang around them. So the number one thing I plan on doing whenever I serve my time and fulfill the sentence of this court is reconnecting with my brothers and sisters in the recovery community, Peer 360, going to AA, making sure that I get a job and continue to work and provide for my daughter and grandkids. You know, as far as having people behind me and having them that structure to build on the foundation that I've already made in that relapse prevention plan, and there's no doubt in my mind that I can be a productive part of society and move forward because I've already used that foundation to stay clean and sober and ticket free in one of the hardest places on earth, Your Honor, and that's prison. I thank you for letting me speak, and I welcome any questions you might have.
Thank you. Your prior prison sentences, were you offered the same programs?
No, sir. I did take the ASAC program before, but I did not take time to customize and really build on the relapse prevention plan. And that's one of the things that the supervisor, Mr. Graham, spoke about. He really took some time to do one-on-ones with me. And, you know, I asked, one of my biggest questions was, what's going to be different? And he was like, well, you have to practice these things every day. And that's, you know, I realized that it's this time in this county jail and the time that I spent in prison that gave me back to my daughter, and not only me back to my daughter, but back to my grandkids and them back to me. But I have to practice these things. Without those things, my addiction's over in the corner doing push-ups, just waiting on me. It's part of who I am. So I have to continuously do these things. Even when the rain lets up and things get better, I can't be like, oh, I made it. I've never made it. I have to constantly practice those 6 principles.
4 total occupants in the car, correct?
Yes, Your Honor.
The other adult was whom?
Jamie Hicks.
Why didn't she drive?
The car that her father recently had passed away, and the car that was left to her by her mother was a manual, and she hadn't quite learned to drive the manual yet. It's something that we were supposed to work on together. When I drink, I make poor decisions. And she didn't see me physically drinking that day. And so when she asked me to drive, if I hadn't been drinking, I would have been like, that's not a good idea. I understand that we need to resolve the situation with the children, but I can't drive. It's not, and you can't drive that car. So we have to figure something else out.
Well, why didn't you think about that before you got behind the wheel?
I'm an addict. I make poor decisions when I get alcohol in my system.
Consuming alcohol is different. If you make the choice to consume alcohol, that's one thing. I understand the addiction there, Understand substance use disorder, but how does that translate in saying, you know what? I'm gonna go pick up 2 children and have another adult in the car with a blood alcohol level of 0.224. How do you say that that's addiction to get behind the wheel?
I'm not blaming it on addiction. Like I said, I take full responsibility, Your Honor. Had I been in my right mind, I may have been able to take, like I said, one of those steps is stop and think. Take a moment to stop and think. But instead, I was like, oh yeah, I'll help, I'll do it, give me the keys, I'll drive. Poor decision, no excuse whatsoever. Poor decision, my fault, 100%.
Appreciate that. Thank you, sir. Mr. Rakowski, on behalf of the people.
Your Honor, we ask you to take into account my statements from the previous sentencing. The court already pointed out the blood alcohol was 0.22. And as far as the reason for the stop, I mean, the child called his mother saying he was scared about the driving. But other than that, we ask you fashion a fair and just sentence, Your Honor.
Thank you. All right, a couple of things to clear up first. When the court made the statement about this the second time, court misspoke, and I admit to that. I was confused because I was thinking of the 2 children in the car. That's why the 2 came up. Also, you've had 2 prior prison sentences for the same behavior, not involving a child in the vehicle, but operating while intoxicated third. Also, the court made the statement brought up by Ms. Dickerstedt about following the law. And I should have said, follow precedents of this court, the precedent of this court. And the law allowed for a probationary sentence. There's no question about that. The law considers as well the sobriety court program. But one thing to consider, a few things to consider. The history of the defendant with drinking and driving is significant. 1997, operating while intoxicated, discharged from probation without improvement. 2003, operating while intoxicated, completed probation. 08, operating while physically impaired, placed on probation. 09, operating while intoxicated, third. There was a violation of probation based upon new felony behavior, to wit, another drinking and driving conviction in 2011, operating while intoxicated, third offense. There he was given jail and probation. 2017, operating while intoxicated, third offense, prison, parole violation. 2021, operating while intoxicated, third, while on parole. There he was given a 20-month to 5-year sentence, discharged on January 22nd of last year. The new charge is approximately 4 months. So the new charge that you are here before this court. So 4 prior felony OWIs, 13 prior jail terms, 2 prior prison sentences, violated parole previously. The offense occurred approximately 4 months after the beginning of parole, drove reckless according to the information provided in the pre-sentence report, with 2 minor occupants in the vehicle, and the child calling expressing fear. The court has to also consider the defendant's history, which the court has had ample opportunity to hear. We're hearing from an individual who has an associate's degree that has college debt, actually, still owing. And so a very intelligent individual, only 45 years of age. Clearly, substance use disorder is the issue. And the question is, well, why can't he be placed in the TRSC program as an example? And the court did consider that, and the court still considers it, but you have to consider the history. In 09, he completed residential treatment. In 2011, he went back, but left without permission, and he was referred to substance use treatment, but never completed it. So maybe just a little over 3 months of treatment, but the services were offered to the defendant, and the defendant took whatever advantage he wanted of the programs or didn't take advantage of the programs. But it shows the court that you have been given opportunities to prove you can be a productive member of society, but we are having repeat behavior. And I go back to the point where, and you stated just a few moments ago, that the person that was seated next to you didn't know you were drinking earlier in the day and a stick shift. That may make sense, but you had a blood alcohol of 0.224, almost 3 times the legal limit, where a special needs child calls her own mother expressing fear of being inside that vehicle. And to the court, drinking and driving, repeated, maybe drug treatment or substance use disorder treatment, TRSC would be a good thing, or TRSC, it is TRSC. But you've been given those opportunities before. Had you been alone in the vehicle, this would be a completely different situation. But you had 2 minor children with special needs, one of which expressed significant fear because of your operating the motor vehicle. And that has to be addressed. It has to be addressed. Guideline range is 12 to 36. You are requesting the 12 months, which is understandable because at least by the 12 months, you've completed those terms with 372 days in the county jail. That would pretty much, or the time that you've been either not on bond, but in the prison system, that would make sense under the circumstances. But here, I have to look at the conscious decision you made to get behind the wheel of a vehicle with other people in the car. That's what this case boils down to. Had it been yourself, might be a different story, but you put other people's lives at stake, of which you need to be held accountable for. It will be the sense of this court that you be recommitted to the Michigan Corrections Commission, placed in the commission's custody for a period, and I'll go with the recommendation, 18 months to 10 years, credit for 372 days previously served. Crime victims assessment of $130 will be ordered. Court costs of $200, it will be $200. A fine of $100, $68 in state costs will be ordered as well. Secretary of State will take appropriate license sanctions, and you're going to be out pretty soon. And it sounds like that the programs that you were completing or involved in at Department of Corrections have been helpful. Let's hope they're so helpful that I never see you in this building or any circuit court again. Because next time it could be a life that you're dealing with, and you don't want that. There's no punishment that a court could give or sentence a court could give that'll bring back the life of a minor child or anyone that's subject to your hands of operating a motor vehicle blitzed. No more. There's no reason to drive. You consume alcohol, consume to your heart's content, but throw the keys away. Don't get behind the wheel, especially if there are other people in the vehicle. It's my duty to inform you of the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, the court will assign counsel for your public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Yes, for probation.
Are attorney fees waived in this?
I'm waiving attorney fees. Yeah, that's all waived.
Under Michigan law, the court conducted resentencing following a prior sentencing error, applying the statutory sentencing guidelines and considering an updated pre-sentence investigation report. The defendant stands convicted of operating while intoxicated, third offense, a felony under Michigan Vehicle Code Section 257.625. In applying the sentencing framework, the court evaluated the seriousness of the offense and the defendant's extensive prior record, including multiple prior OWI convictions, prior prison sentences, and repeated probation and parole violations. The court noted that prior rehabilitative efforts, including substance abuse treatment programs, had been offered but did not prevent continued reoffending. Aggravating factors included a blood alcohol level of 0.224 and the presence of minor children in the vehicle, which elevated the risk to public safety. The court determined that the defendant is not amenable to community-based sanctions and that incarceration is necessary to protect the public and impose appropriate punishment. The court imposed an indeterminate prison sentence of 18 months to 10 years, with credit for 372 days previously served. Additional financial penalties and license sanctions were ordered pursuant to Michigan law, along with eligibility for post-release supervision under the jurisdiction of the parole board.